Hey, hello everybody. My name is Bouvier Yulin and I'm the director for SCMA. Welcome to today's webinar, Mediation Briefing Excellence, Avoiding Common Pitfalls and Putting Your Client's Best Foot Forward. This webinar is eligible for 1 hour of MCLE credit and 1 hour of MC3 continuing education credit. If you are requiring MCLE credit for attending this event, please check in by putting your name and state bar number in the chat. We also have handouts in support of this webinar, which I will put the link of the handouts in the chat as well. I would now like to introduce our moderator for today's webinar, Jim Cameron.
Thank you so much, Bouvier, for the kind introduction, and thanks to all of you for attending today. I'm Jim Cameron, and I am the co-chair, along with Craig Lang, of SCMA's Attorney Outreach Committee. We try to present at least 3 programs a year geared toward attorneys more than mediators to enhance the lawyer's understanding of the mediation process and how to use it most effectively. Today's subject is no exception. We're going to be talking about mediation briefing excellence. I'll talk more about it in a minute and then introduce our 2 wonderful panels. I want to thank the members of the Outreach Committee, especially Daniel Epp, who's helping us with questions today, and Craig, Sydney Kanazawa, Leslie Kushner, Marlon Schulman, and our newest member, Mikan Shelton. We work throughout the year to present programs. There'll be another one in March during California Mediation Week, and our 3rd one will be probably sometime in June or July, so watch for the details. A couple of housekeeping items. You have the link now to the online materials, which include not only the program outline, bios, and photos of our 2 speakers, but also the relevant provisions of California's Evidence Code, and then links to a couple of articles about mediation briefing, which we thought you would find helpful. Feel free to look at those at your leisure if you want to take a deeper dive into any of these things. We'll be taking questions at the end, folks, and please put your questions in the Q&A, not in the chat. We will be monitoring the Q&A. We will not be monitoring the chat. If you want us to address a question, put it in the Q&A. We'll deal with them at the end. We're happy to stay a little bit beyond 1 o'clock if need be to get to as many of your questions as we can. Before I introduce our 2 panelists, I just want to say a few words about our topic today. It's a subject near and dear to my heart, which is how to write and present excellent mediation briefs. I want to tell you why mediation briefing isn't just standard writing for the court and why this isn't a standard writing seminar. We're not going to talk about basic grammar. We're not going to talk about how you organize your thoughts, that kind of stuff. But we're going to talk about what makes a mediation brief different from what you are going to be sending into the court and how to make your briefs better. So, fundamental to me, think about who is your audience that you're writing to, and what do you plan to send your brief to that person for what purpose? Is that person a sitting judge? No. Will the mediator be making a decision or writing an opinion after the mediation concludes? No. So, what will the mediator be doing? We'll discuss it. It's about facilitating a conversation, exploring possible ways to settle the case. This is fundamentally different from what you send to the judge. If you don't write to your audience, if you send your standard MSJ brief to the mediator, it's not going to help, okay? And if you're going to have a successful mediation, help the mediator with his or her job. That's what we're going to explore. So with that background, I want to introduce our 2 wonderful panelists, Stacy Feldman-Hausner and Mark Lemke. just a couple of words of introduction about them, what they have in common. They both started their mediation careers by getting their LLM at the prestigious Strauss Institute at Pepperdine. They happened to be there at the same time, so they've been close working colleagues ever since their time at Strauss. They're both very committed to the training of mediators, teaching people on the way up. More recently at this end, they are both among the younger inductees into the International Academy of Mediators. Now, what does that mean, ladies and gentlemen? In a few words, that is the top of the heap. It's like your Martindale AV rating times 10. It is the absolute pinnacle in the mediation profession. You don't get there easily. You only get there by invite, and you've got to be really good to get there. Both Stacy and Mark are extremely successful mediators. They have great practices. They've done thousands of cases. Mark has his own practice, which is called Lemke Mediation, and Stacy is a very distinguished member of ADR Services in Los Angeles. As far as I can tell, they're the best and the brightest of their generation of mediators, folks who have made it to the top of the heap before they get to be my age, if not older. So it's my pleasure to introduce them to you. And if you want to read more about them, you've got their full bios in the program materials. I don't have to repeat all that to you. Stacy and Mark, thank you so much for coming today and for sharing your wisdom. We're going to kind of go topic by topic here, starting with one of the two of them, and then having the other chime in as appropriate. And we'll try to get to all of the 6 topics that are on your outline in the program materials. So Mark, let me introduce you first for our first topic, which is, for whom are you writing your brief? What are the objectives, and how does this differ from what you send to a judge? So Mark Lemke, let me turn it to you, and Stacy, please chime in when you'd like.
Yeah, I think that you hit the nail on the head, Jim, that a mediation brief is designed to help the mediator help you settle. It's not about winning. If you want to win, we got courts for that. My job is to help you settle the case. So help me help you. What is the information that I'm going to need over the course of the day? And one of the big differences, as you were correctly pointing out, Jim, between me and your judge, is if I'm never going to mention something that you wrote in your brief in the other room, don't give it to me. The bottom line is that people typically hire mediators in large part for subject matter expertise. I don't need you to tell me that California adopted the Fair Employment and Housing Act and spend a couple of pages on that. I'm just going to be flipping right over it. If this is a housing case, I don't need you to cite Green versus Superior Court. If I didn't know that, you wouldn't have hired me. So keep it to what it is that I'm actually likely going to be working with in the other room. Just a few thoughts off the top of my head. By all means, Stacy, please.
Well, I'll jump in here too, because I agree with this. First, though, Jim, that was the nicest introduction. Thank you so much for that. I really appreciate it. And Mark, it is so great to work with Mark. We did go through Strauss like 10 years ago together. And so this was really fun for me. And I appreciate all of you taking your time to listen to us. I know we have some mediators out there, some lawyers out there. So this is really fun for me. I want to say that I like this as the first question, because this is a very important one. And I just think as a general rule, before you draft the brief, ask yourself, what am I trying to accomplish in writing this, right? We are here to help you get to a resolution. And I want you to just keep that in mind. It is very different than a judge. I do agree with Mark on that. We are here to help you resolve it. And that has a lot of different components to it. It's not always just law and facts. There's so much there. We're going to get into all of that with you today. But I do think that it's really important always to say, what am I trying to do? You're trying to get us to help you resolve it, and you're trying to get the other side to think what you think is a good settlement so that they'll accept your evaluation of the case and the settlement. And if you just keep those two thoughts up there in your mind as you're going through that, I do think it's going to be very valuable.
One other thing, I'll share that I'm sure every mediator is different. But when I get a brief, the first thing that I do is I flip to the last page. That's going to tell me a whole heck of a lot about how that day is going to go, or that half day is going to go, because usually the last page will include settlement discussions. Now, I know we're going to be talking about components of a brief here pretty soon, but please make sure that prior settlement discussions are there, and that's usually where they would be, or on the plaintiff side, what your likely demand is going to be and how you get there. If I see that we've got a delta between a plaintiff and $1 million and a defendant who sees that this is at least a six-figure case, okay, that gives me a good deal of hope. If I see that the plaintiff says that this is an 8-figure case and defense counsel is saying it's worth less than the cost of filing an MSJ, that gives me a better idea as well. Likewise, if this is court ordered, or if this is contractually mandated, if this is a check the box to be able to report back to the court that, yes, Your Honor, you wanted us to mediate, and we did. We used Stacey Hausner, so we went right to the best, and we weren't able to get it done with Stacey, so you know that we need to go to trial, Your Honor. Or if this is pursuant to an arbitration agreement, the parties have to go through a mediation before a demand for arbitration is filed. Let me know, what are we looking to accomplish and how can I best help you in the time that we have?
Yeah.
I agree with that. I actually don't flip to the last page. I just read it conventionally from start to finish. But I do find it critical to know about settlement negotiations, because you are creating anything you've negotiated before you get here creates an expectation with the other side that that's the number you're starting at. So you're creating floors and ceilings before you get here. Now, sometimes something has happened in the litigation, or costs have gone up, but costs have gone up on both sides. And so now my gap is even wider if we're now considering costs. And I need to understand that dynamic to be able to get you towards a settlement. So I do think that is very important. And like Mark, I do think venue is very important. So if you're in arbitration, the costs are different. The risks are different if you have a lawyer or a judge deciding the case than if you have a jury. So all of those things I think are very important. I like them in the brief. We're going to get into all the details on that. But I typically start at the beginning of the brief and I want to know who are the parties. We'll get into all this. So I read it more conventionally than Mark does, but I'm looking for it as well. So I appreciate you bringing it up.
Let's, as a segue to that, switch to the second item on the outline, which is how long should your brief be? And as a sub part of that, does it vary according to whether you have a full day mediation or a half day mediation? I'll just say that there are no rules of court on this or local rules on point here. It's not like, motion practice or demurs or MSJs and that sort of thing where you're told you can't go beyond this at all unless ... So this is flexible, but what's optimal? And Mark, again, I'll throw it to you first, and Stacey, please offer your wisdom on this.
Yeah, I did a little bit of a equivocation hand signal there when you were saying there's no rules of court. Know your mediator, know what it is that she is looking for as far as length goes. But it's not without irony that I frequently see briefs that are 30 pages long, 40 pages long, sometimes 40 pages single spaced, and somebody has the audacity to call that a brief. I'm going to be that guy for just a second. And Oxford's English Dictionary, which I have up on a second computer, as an adjective, a brief is of short duration. Remember that. As a noun, a concise statement or summary. I will forever remember somebody who had the case of a lifetime. I mean, this was a case that lasted their entire career. They submitted a 47-page brief to me, and the one thing that they didn't include in all the twists and turns, all of the procedure, all of the appeals, is the defendant had declared bankruptcy. And the only way that the case was going to settle was for pennies on the dollar because there was no insurance, there were no assets, there was a tiny, tiny, tiny little sum left to try to get a bunch of different cases done. Nowhere in that 47 pages did it tell me that. So make sure that you're arming your mediator with the tools that she's going to need to be able to settle. Now, as far as an appropriate length, I do think, and I think it's an important thing that you brought up, Jim, I do think that it matters whether it's a full day or a half day. And the reason that I say this is I've found, especially over the last few years as we've made the switch to online, that people are taking the approach that if it's a half day, I need my brief to be twice as long because we have less time to talk about the case, so I need to put more into the brief. Well, under the header of Know Your Mediator, if we have a half-day mediation, that means that I either have a half-day mediation before you or after you, which means for that half-day, I've got to read 2 times as many briefs. Or if this is a 3-party case, then I have to read 3 times as many briefs. So bear that in mind. I wanted, Jim, if we can do the word cloud, I'm going to attempt to share screen here.
Go ahead.
And yeah, it's not letting me from my computer, so I don't know if you're able to pull up the graphic. But the key thing is.
Oh wait, hang on. Let me enable you on. No.
Not critical, not critical. But I find that oftentimes people bury the point that they're trying to make. You know, Stacy was talking about, know your goal. And if you've got dozens of pages of facts and timelines and procedural detail, I may miss the key point. So make sure that your key point, your key theme is woven throughout. If there's a big issue that you know is going to be coming up in the mediation, address it head on. And under the header of detail, I'm not a drinker, but I know a lot of mediators. Okay, so here we go. So this is a word cloud that I created, and you see a whole lot of fact, a whole lot of date, a whole lot of detail, and it's very easy to miss the point in all of that. The point is in there, but you really have to work for it, and it's easy to miss it. So thank you very much, Jim.
You're welcome.
So as far as making sure that your mediator has what they need, you know the case better than I do. What do I need in the time that we have? What is the likelihood that I'm going to be working with that particular fact, that particular detail in the other room? And if I'm not going to, probably you can skip it. Stacy, welcome thoughts.
Yeah, I agree. I love that you brought up brief with the dictionary definition. That's fantastic. I typically say, as a general matter, a half day, 5 to 7 is great. They're a lot of times longer than that. Full day, just to give you more concrete guidance, 10, sometimes 10 to 20. It depends on the sophistication and complication of your case. I would say, be careful not to be repetitive. A lot of times you'll lay it out and then lay it out again and then lay it out again. We typically know the law, although if you think the case and the dispute turns on a nuance in the law, please give it to us. But I want to say there's so many drivers here, and any mediator that's mediating all the time will tell you each case is very, very different and depends, and the issues that we need to know about vary. So again, it's back to that, what is happening in your dispute? So I had a partnership dispute last week, and they gave me, in lieu of a brief, one of the attorneys was very busy. He gave me a summary judgment motion, and he gave me an opposition to a motion plaintiff had filed to amend the pleadings. Okay, that's better than nothing. However, it's a partnership dispute, and likely the ego and emotions involved in like a breach of trust is going to be a big driver or something I need to know about in this case. And by giving me just the legal arguments, the good news of it is with the summary judgment, you lay out the facts. So I got a sense of what was going on, but that's not the most advantageous. One thing I want to say is keep in mind, so my general practice is, because I mediate every day, I read the brief in the morning. I'll skim it the day before so I can have a pre-mediation call, and we'll talk about that. But I read in the morning before, like I get up at 5 and I read the brief. So keep that in, so I need to be fresh with all the facts. Keep that in mind, right? If you're giving me a 50-page brief, that's going to be really, really tough. So just keep that in mind. I want to say, I don't care about format at all. So an email works as a phone call works, although the phone call is usually on top of a writing that I can read. So the formality doesn't matter so much to me. The information that we're about to get to very shortly is what's going to matter. But keep in mind, you're trying to make it easy for us to understand the dispute. So that's what the brief is about. That's what your goal should be with the brief. And just always keep that at the back of your mind.
Couple of things I want to pick up on, Stacy, that I think you said that were very important. When people send you a motion for summary judgment rather than a brief, there's one thing that I really appreciate about motion for summary judgments, and that's that you have to have every fact that's in your motion be in your separate statement of undisputed facts. And the parallel that I want to draw here for brief writing is, if you are sending your mediator a particularly long brief, make sure that every fact that you're going to work with is going to be in the fact section. And the reason that I highlight that is because sometimes people will intersperse that key fact that they mention only the one time and bury it in a discussion of the law, and a section that I think that I can just skim through. Oh my gosh, I didn't see that key fact because they just mentioned it that one time. So I definitely would encourage, if you're going to do a motion in lieu of a brief, or if you're doing a brief, make sure that all of the facts that you're working with are laid out in the fact section. You can, intersperse them as well in the legal discussion or elsewhere in the brief, but make sure you've at least put it into the fact section. One other thing I really respect and I'd be very curious to know how you enforce this, or if you do, but I really respect that you say, here's how long, the brief should be for half day, for a full day. I tend to defer to the parties, and it doesn't always work out for me. But one thing that I will note about the length of a brief is that an especially long brief usually signals to me, these are not people who want to settle. These are people who are so dug in on the argument and so certain of their position. Probably these are not people who are coming to the table to settle. So is that the impression that you want to leave your neutral with? Also, I'd say that probably once a week or so, I have a case where there are 3 parties. So it's not just the conventional 2 rooms, it's 3 rooms. I typically will start with whoever wrote the shortest brief on those days. But that's going to give me a little bit of an architecture.
Rewarded.
Yeah. So if you are, one of a 3-party case, a 4-party case, you may want to be as concise as possible, because that may put you in the pole position.
That's really funny. Okay, first of all, I want to say I don't enforce it. I'm just giving you lawyers a general guideline. So like Mark, if it's half day, oftentimes I have another half day. So just think how many briefs we're reading on this day. Also, you only need 4 hours to resolve the dispute. So I just, use it as a general guideline. I don't enforce anything. I read everything you tell me to read, so that I can be prepared. So it's also helpful. If you find it important, there's a reason you find it important, and I will read it and be ready for you. I don't do that. I haven't really paid that much attention to length of brief, in all honesty, until Mark and I talked about it a week ago. If you're outrageously long, so if I click to read your brief and it's 200 pages, then I notice like, oh no. But typically, most of you are pretty good at it, and you make sure that it's brief. So I don't have any rules. I read what you give me, but I think, look, you don't want to irritate. And if you're with Mark, get that brief short. You go first.
Yeah.
Get your issues out there.
There was For three-party cases. For a two-party case, yeah, I've got different criteria that
Different rules. Yeah.
One thing that I wanted to note as far as the length goes, and this is just anecdotal, you know, Stacy, you and I, we each have our regular clients. We each have things that people compliment us for doing especially well. One thing that I frequently hear is, Mark, you read the brief. I so appreciate that about working with you because you actually read. And, you know, to my mind, that's kind of damning with faint praise, but I'll take it. But I wonder for people who are not having their briefs read, if it's because they are so long that the neutral looks at that thing and says, there's nothing in here that's going to help me settle the case. This is just somebody who's papering me, who's burying me. I'm just going to start fresh because, kind of like Stacy, you were saying with the partnership dispute, here's a whole bunch of stuff that has nothing to do with the actual dynamic that I'm going to be facing as the neutral. Also, while I was saying that I tend not to be a big drinker of alcohol anyway, I know lots of mediators out there who will read all their briefs for the week on the weekend. And, you know, or the night before, pour themselves a nice big glass of wine and read through all their briefs for the next day. So as far as the length, as far as the detail, bear that in mind. With Stacy and I, we both wake up 5 o'clock and start reading our briefs immediately. With me, it's a big cup of coffee or a few cups of coffee. But, you know, if you're working with somebody who's a little more senior, who's going to be reading all their briefs for the week at once and possibly after a glass or two of wine, how much of that are they actually going to remember?
Yeah, I train mediators, and I always think, and I really think this, the number one thing mediators should do is be prepared. So when I hear this, Mark, I just shudder, like, how could they not read the brief? How could they not be ready? So I hear this and I'm like, oh, I got to bring that up to the mediators. The number one thing, mediators that are prepared can, if the case can be settled, can get that case settled. So
That's exactly right.
If you mediators out there, read your briefs is what I want to say.
Well, Stacy, let's get into the actual components. And I know you've got your list. So everyone
I
pay
have a
attention.
list.
Pay
So I
attention
was
to
on
the
a
wisdom
plane.
about to be dispensed.
I was on a plane yesterday for like 6 hours. I'm like, I'm going to make a list of the things that I think you should have in your mediation brief. And Mark, jump in on all of these. You agree, you disagree, tell me what you think as well. So I made a list of what I think you should have. First thing is parties to the dispute. And that seems so elementary. And you're probably saying, what? Of course. This is not always happening. So I will look. It happens all the time. I have a plaintiff suing defendant. That's clear. I can see they're listed on the caption. I can see the lawyers are coming here. But sometimes there's does, there's related entities. I don't know who exactly is coming in. Names will come up to be entering into the mediation, and I'll let them in one by one and they identify themselves. So I may have a management company member coming, or it happens very frequently. So the first thing you want to do is list out to me, who are the parties? Who are they represented by? What is their role in the mediation? I had a failure to disclose real estate. I do all types of cases. I had a failure to disclose case with the water intrusion issues, and the buyer was suing the seller. Typically in these cases, we also can get a broker or the inspector and whatnot. But all that I saw was the buyer was suing the seller. Nobody mentioned anything else in the brief. And then in came my buyer and in came the broker, and I had coverage issues. So I had coverage counsel. This became such a different thing. So mediators out there, as a practical point, set up extra breakout rooms because you never know who can be popping into the mediation. But in the brief, make it clear to us. So that's the first thing component. I just want to do a little caveat here. So I do pre-mediation phone calls, and I do it when you kick me out of the room in the mediation to talk alone with your client. That's when I'm very diligently calling all the parties, trying to talk to them about the next day. When I say include this, I don't mean it necessarily has to be in my brief, but it has hopefully you can get me that information before the mediation. So what I'm saying, when parties to dispute, if you want to tell me about it on a phone call, fine. If you want to email me about it, fine. Or you could put it in your brief, but just get me that information. I know, Mark, you don't do the pre-mediation phone calls, so I want to open it up to you if you have a different view on all this.
As a matter of course, I don't do pre-mediation phone calls. I will absolutely do it if the party thinks that it's going to be helpful. Happy to, we'll find the time. But yeah, I agree with you 100%. Please, please, please let me know who's coming so that I know where to get them. And that helps to expedite things so much. I remember this is a mistake that came up exactly one time and only one time. But I had somebody who was logging in. I had no idea who they were. So I asked, and they said the name of the plaintiff. And I said, oh, so you're with the plaintiff's room. And so I moved them into the plaintiff's room, and I got a text from plaintiff's counsel. How come so-and-so is in my room? They shouldn't be here. I immediately yanked them out. And he said, why did you put me in the plaintiff's room? I said, because I asked you which room you're in and you mentioned the plaintiff. Oh no, that was just the case. I'm in the defense. So you never want to have something like that happen. Please tell me, yeah, if coverage counsel is coming, if a broker isn't coming, an inspector's coming, please give me a list of who all's coming. I will ask that at the outset for each counsel now, if I don't see it in the brief, but sometimes additional people show up. So please let me know who and where to get them.
I like that you bring that up because as a practical pointer, me too, because once this happens a couple of times, I'll bring in the lawyers that I do know first. I'll talk to them alone, see who's coming, get their cell phone numbers, because I want to be able to communicate with you outside of just coming into your room in front of your client. But I do now also, as a matter of course, who's here, talking to the attorneys, because we need to know that in order to set up a productive process. So I like that you bring even that in. The other thing is, oh, go ahead.
If you tell us that in the brief or you tell us that early, then that saves the time that we have as we're getting people in, or saves the time when you're on your call, so that we can be as efficient as possible and get people in as quickly as possible.
Yeah. I agree. Okay. Second, relationship of the parties. So is this a one-time encounter like an accident case? Is there a past relationship? Is there a potential for a future relationship? This is helpful to me when I'm determining what's the drivers, what are my potential obstacles to settlement, and how to communicate messages. So do I have cultural issues? Do I have emotional and ego type of concerns? Do I have trust issues here? That's important to know, because sometimes I just see a list of entities and I don't know, you're not clear with me how everyone's related, what their role is in the dispute. So family members, best friends, sometimes I just see names and I can't tell, are they related? Are they not related? Are they friends? Please give us this, all of these dynamics are critical for us settling the case, because we are messaging and we are trying to be productive in our messaging. And if we don't know the relationship and all of a sudden you spring on us, they're family members, you could create an obstacle or an impediment to settlement that ordinarily wouldn't be there. So please, please, please let us know how everybody is interconnected. Okay, and Mark, just jump in if you want to add on to any of this. Who is attending the mediation and their role? We just covered that. Who are the decision makers here and who's in control of the conversation? So pretty quickly, I can tell who's controlling the conversation. Sometimes it's attorneys. Sometimes attorneys don't say a word and the client's controlling everything. Sometimes my decision makers are outside of the room and I need to know that. So I did a flood case. This haunted me a couple of years ago, and we got it settled and I had 5 different parties and everybody had agreed. And the guy says, you know what, my dad's a lawyer, let me call my dad. But dad hasn't been in the mediation and the parties didn't share their mediation briefs. And now dad is controlling this mediation. I got to know that. I really do. I explore for that before in the pre-mediation call. If you have an elderly person, sometimes they need their support person or somebody who's not an English speaker or a child or a best friend. When these are high dollar cases, especially, well, not even just high dollar cases. People want to run it by someone. Let's tell me who needs to be in the mediation. Let's get them there. Call me. Let's talk about it. I tend to like everyone who has a role in decision making in my mediation, if possible. You don't always listen to us on this, but I try to. So let us know what that dynamic is going to be like in your room. Lawyers call us, tell us, or put it in your brief. I want to say something. If you share, just something to keep in mind, if you're sharing your brief with your client, which a lot of you do, especially like business disputes and whatnot, but a lot of times you share it. There may be things, and there's often things you should be telling me without your client listening, like client control, trust issues, client expectations. Maybe they are just, we'll go into it a little more. If that's the case and you're sharing your brief, then really call us mediators or email us some addendum that you want us to know, because we can really help you when you have client control issues. I think that the client can be an impediment to settlement a lot. And I need to work with you, lawyer, on how together we can get your client to evaluate the case more realistically. So please let us know. Mark, you want to jump in on that one?
Yeah, agree entirely. This is where I think that you have the pre-mediation call as a matter of practice. I don't have it as a matter of practice. I leave it up to the attorneys to reach out if they think it's helpful. But certainly as I'm admitting people, this is, it's just you and I. What do I need to know? Because increasingly, exactly as you said, people are sending briefs to their client. I call it a client-facing brief. And usually that's where I have the really strident tone that they're using and the absolutist language. And sometimes what that tells me is, okay, we've got a client control issue here. It's not necessarily that the attorney really believes in their case. It's that the client is probably vetting every word that's making its way to me. So that's a dynamic that I'm certainly going to have to work with. Obstacles to settlement, I always appreciate when people include that as a separate section. If I see that particular heading, I'm going to jump to that. Have we not yet satisfied the self-insured retention? Is there a bankruptcy looming? Is there a business relationship, as you were pointing out, Stacy? What are the things that I need to keep in mind that are going to help me settle this case, or at least avoid stepping on a landmine and blowing things up, other than just the facts and the law? I like to know venue. Are we pre-litigation? Are we pre-arbitration? If we're in arbitration, who's the arbitrator, so that I can look that person up and get a sense of her background? If we're in court, where are we in court? How it is that I'm going to be talking about a jury that's downtown Los Angeles is going to be very different than a jury that's in Kern County. So very helpful for me to know all of that as well. Don't know if there was anything else we wanted to say as far as sections in the brief.
Oh, I have a lot more sections.
Yeah,
Real quick.
Let's go through your list, Stacy.
Okay. Obstacles to settlement, I think that is critical. We're here to help you get to resolution. So Mark, I 100% agree. Let me know what they are. And oftentimes spend a little time figuring it out yourselves, right? We need to know what it is. And a lot of you lawyers are really savvy on this. And you can say, look, my client, it's going to be a trust thing. He's so upset with this person. Sometimes I've had lawyers say, don't message anything from me. The plaintiff lawyer hates me. Message from the other defendant. Those are types of things that can really help us avoid cognitive biases and pitfalls that we can get. So Mark, I love that. Obviously, heading, we want to know if legally, factually, we cover that. Procedural posture of the case. Where are we? Are we pre-lit? That's going to change everything. Are we with a dispositive motion pending? That's very important to know as well. Are we after discovery cutoff, an expert cutoff? All of this, very helpful to me to know in terms of messaging, in terms of knowing the costs that have been put in this far and dynamics that aren't related to law and facts necessarily, but the procedural dynamics can also create a barrier to settlement or a path to settlement. So I definitely want to know about that. Clients, I'm going to pick it up a little because we have some more topics to cover. Clients' interests, goals, motivations. That's all the stuff that's underlying the positions. And when we train mediators, I'm always, we have getting to yes and how to ask questions to explore what's really going on here. What's the goal? If you know it, tell us. If you don't know it, we're going to be talking about it and looking for it. So we'll be able to help you figure that out. but what's driving their positions is essentially what you want to know. And if you know it, tell us. And if you want to tell us without your client, call us or email us or whatever it may, or tell us before we let in your client. Because both Mark and I are going to give you an opportunity to tell us stuff right when we let you into the mediation without your client listening. Another thing is the position of the other side. You tend to do that because when you're talking law and facts, you're disputing what you think they're going to say. It tells me if you don't do that, that you may not be really considering this. And that gives me a message as well. So if you don't understand where they're coming from, and sometimes you don't, by the way, with pre-lit, you don't. So we're asking those types of questions. But if you do, it can be helpful because then I'll know if you're understanding their position, if there's a misunderstanding about the facts or misunderstanding about the law, and it can focus my conversations early and make me more productive as I'm going through the settlement. So I think that's helpful. Mark, jump in if you have anything to say on this.
Yeah.
Go ahead.
Couple things that I would just add, and this is a little more big picture, but we're all keeping an eye on time, of course. I agree with you to preview your responses to the other side's arguments, but I do sometimes see people who spend too much of their brief, so it really is a balancing act, just telling me the other side is going to argue this, the other side's going to argue this, the other side has this exhibit, the other side has this witness. Well, what do you think about that? What's your response to that? How are you going to counter that? So it is a balancing act between, you know, what the key issues actually are, focus on the issues as you understand them. If something new comes up, and it always does. I mean, I've yet to read a brief that addressed every single possible contingency, every new argument that could come up. But make sure that it's your brief and you're really focusing on your arguments or your counter arguments. One thing that I would note, and I have a varied practice. Most of my cases are employment, personal injury, housing cases. I've done some wrongful death matters. But I've worked with firms that are high volume. I've worked with boutiques, and the strategy and briefing that I see is very different. The big thing that I would caution is read your brief. Don't just write your brief, read your brief and see if it makes sense. The example.
That is so funny.
The example that I have there is, and I've received, I wish it was, you know, just one time that this happened, but I've seen a number of briefs where page 1, isn't it terrible what the defendants did to my client, an honest, hardworking South Asian elderly man? And then page 2, can you believe what they did to my client, who is a recent immigrant to this country from South America and a single mother? And then page 3, can you believe that they did this horrible thing to my client, who is an African-American disabled person? I don't, at that point, I don't know what I'm reading anymore. I don't know what case this is. And it's not clear to me that you know what case this is. So under the header of help me help you, make sure you read your brief. We all copy and paste, we all multitask, we're all too busy, but make sure that you read your brief and not just write it. Make sure that it makes sense.
This is so funny, Mark. This has not happened to me, but that is funny. To add on to this real quick, another thing I want to know, is liability contested, or is this a damages case? Am I talking about pre-existing conditions? Am I talking about liability? Where are my issues in this case? So please let me know. When I do PI cases, sometimes liability is not contested. Obviously, I can figure it out also, but just be straightforward with us, because even sometimes when I think liability is not contested, they're talking liability. So let me know. It's going to structure me as well in the conversations. Timelines, I love them. If you don't do them, I do it myself, especially like with employment cases or anything that has lots of dates. I have to know treatment dates in your PI cases. These are very beneficial timelines if it's relevant. Obviously, if it's a few dates, you don't need it. Bullet points. So that's a great shorthand way. And I pull up your brief while I'm mediating. I have your brief up as well. So I'm looking at your arguments and looking at your, if you have all these bullet points, it's really great. The other day somebody did for the first time ever with me, a lawyer told me what they wanted to tell me in caucus and sent me into the other room with a bunch of arguments. And then she emailed me the arguments, like in bullet point fashion. I've never had someone do it before. I liked it. I can't say I needed it, but I liked it a lot. And anything that's going to make it easy for us not to skip anything, I thought that was very helpful and interesting. Demonstrative evidence. So some of you put pictures into the brief. I like that. It's right there in the brief for me. Now, I want to say some of you give me 1,000 pictures. That's not so helpful. And that's that whole like argument dilution and show me your big pictures, cut and paste your critical depot testimony or the provision of the lease that's at issue. I do a lot of landlord tenant. But if you have demonstrative evidence, if you have, people can consider objective raw data better than like an opinion or an argument. So if you've got it, you should use it and let us use it for you so that people, the other side, can listen. Mark, are you wanting to speed us along?
I was saying give it to us, but I think that Jim did have another question.
Yeah,
okay. All
what
right.
you were talking about with demonstrative
there.
evidence, I want to make sure we spend at least a couple of minutes talking about exhibits, which kind of fits in there. And then I want us to be able to spend a few minutes before we go to questions talking about do you share or not share a brief. But exhibit seems to fit in with what you were just talking about. And Mark, you want to go first on that?
Yeah, Mark, you take this.
Yeah, so again, I think that here you really want to focus on what are the key exhibits likely to be. I'm not the arbitrator. I'm not the judge. It doesn't matter if I think that your case is fantastic, if I can't make that point effectively in the other room. And that's where give me the key exhibits, whether it's exhibits in the brief itself, which I'm so impressed by, even to this day. Maybe I shouldn't be, but I'm still so impressed when people are actually able to copy and paste the exhibit into the brief and show me, what is the relevant portion. I remember a newer attorney who sent me 5 deposition transcripts for a half-day mediation, whole deposition transcripts. And I asked her, I emailed her that morning, hey, what are you wanting me to see here? Response, how they testified. Anything in particular that I should be paying attention to from these deposition transcripts? No, just generally. You shouldn't send me something if it's just for my general understanding of the case. Send me the things that I'm going to be able to use to hammer home the point that you want me to hammer home in the other room. If there's a key admission, I love it if somebody has the ability to just copy and paste those 3 or 4 lines into the brief. That's great. Or give me the page line side, as well as a condensed transcript. What I don't need is your entire file. What I don't need is somebody to send me a website, a Dropbox. There's an old joke about somebody who goes to a doctor and complains, it hurts when I raise my arm like this. And the doctor, she tells him, don't raise your arm like that. If you're having issues in sending your exhibits to the mediator because there are so many exhibits and the file size is so large, you probably shouldn't be sending that many exhibits to the mediator. So if you want to send, the key stuff to me, great. If you don't even mention it in your brief, I probably don't need that exhibit. If you don't need it to make your argument, I'm not going to need it to make your argument. If it's just, hey, please, I respect you, I trust you, I'm going to send you a copy of my file just in case we wind up needing this stuff to speed things along. Let me know that that's why you're doing it, as opposed to, here's my file, you figure it out. But this is the help me help you part.
Exactly.
Mark, I agree with you so much with regard to this. It is very helpful if you tell us where it is. So a lot of you want to send the whole context of it because it may come up in the mediation. So then it's easy for your mediator to reference. I want to say, don't worry if you don't send in the brief, because you can always share it with us during the mediation and we'll do share screens and whatnot. And you can point out the part of the document or give it the context. So don't feel like you're missing out if you don't send me the entire lease agreement, because we can get to that. But one thing that's helpful, like I had an accident case with a 23-year-old boy who was injured in a car accident, and he and his depot said, I cannot move at all. It's 10 out of 10. And the lawyer cut and pasted that depot testimony and then said, here's a sub rosa video, look at 20 minutes in and look at 30 minutes in and look at, and gave me the exact times. And at each time, this guy was throwing the ball hundreds of yards for his dog and bending and running in the sub rosa. So that's very beneficial. If he just gave me the 45-minute sub rosa video, I don't know I'd actually be able to watch the entire thing. So I agree with you, Mark, and I agree that if you're having trouble sending it, there's so many, you lose the impact of it. Like habitability, sometimes there's thousands of photos. Give me a sampling and then you can show me more and we can send it to the other side and we can work together to make an impact with that evidence once we're in the mediation. So
if I can add just one thing here, some of our cases are either business disputes involving agreements, or a lot of the work I do is in the probate field. And I do think that it is, if you're arguing about what a will does or does not provide, you want to make sure that the mediator has access to it. But to your point, Stacy, it's in paragraph 3 on page 2 is very helpful. And if you can cut and paste per what Mark is saying, even better. But sometimes people overlook other parts of the document that may be relevant to what it is you're trying to resolve. So, but it's really good. We're getting close to closing time, but I want to make sure we spend a few minutes on, do you share or not share your mediation brief with the other side? And I will just say to everyone listening, the 2 articles that are in the program materials both talk about this at some length. That's why we included them. There are arguments pro and con, and we could probably do an entire program about this, but let me throw it to the 2 of you. Do we share or not share? Stacy, you want to go first?
Okay, so generally speaking, I say share. Why do I say share? It enhances your presence at the mediation. Your whole goal is to get the other side to evaluate the case the way you do. So if you have outside decision makers, which a lot of times you have, especially if you have an insurance policy at play, they round table, they come to the mediation with authority. I'll do like a lot of HOA boards and school boards and whatnot, decision makers out of the room. You want them to see your case and evaluate the case like you do. So this is a strengthening position. Now, I say this with a caveat, a couple of things. One is you have to balance it with litigation. And if you don't settle it, you're still in the litigation process. And a lot of you attorneys are concerned about showing your hand. And you don't want them to know this argument because you're going to be taking a key depo the next week, or you're going to file a motion for summary judgment, and you don't want them to manipulate the evidence in a way to dispute it. So I respect that too. And I say, you got to really think about, do I want to go for settlement? How much risk is there in this? And discovery cutoff will play a part in it, and pending dispositive motions may play a part in it. Look for that balance and make that determination. Is it worth it settling? Is it worth it to share it? If it is, I say share it. Now, do you have to share everything that you share with me? Absolutely not. Don't talk about vulnerabilities, weaknesses, settlement positions, client expectations, whatnot with them. You want to share with them maybe your position. It saves a lot of time for these half-day mediations because they have a general baseline of where you're coming from. And I can also tell you that they discount it so many times if they haven't heard it from you before. So if you're far along enough in the litigation and they've never heard this argument and you've never pieced together evidence in the way you're telling me in the mediation brief, and to me, they're going to say, you know what, that's ridiculous. It's an ingenuous argument. I'm not even going to consider it for settlement. So many times lawyers say, I've never heard it before, I'm not considering it when I'm evaluating my case. You don't want to be in that situation. You want them to have heard it, to consider it, to evaluate it, and come in with an evaluation and value for settlement more similar to yours. So keep this in mind when you're thinking about it. Some lawyers say to me, I'm not sharing it unless the other side shares theirs. I still think you could share it if you're a plaintiff with decision makers outside the room. I would encourage you to share it even if they don't. But if you're particularly concerned about that as an attorney, you can just make it conditional. Reach out to the other side and say, look, why don't we share our briefs? You know, that's a very collaborative tone. I like it as a start of mediation, and see if both of you will share it. I have you share it directly, not through me. I like the collaboration of that. It's a little influence technique, but also I don't want to get involved in that. So if you're sharing, use a productive tone. Don't call them names. Don't call their lawsuit frivolous. Don't insult them. Read it and say, would I find this insulting? And if you're not sure because you're so entrenched in this, have your associate or partner take a look at it. There's also AI tools now where they can sanitize some of your arguments, but you gotta, if you're sharing, be very, very careful with your tone, because you don't want to create an obstacle to settlement that would not already exist. So that's my very shortened version of why I encourage it when it's appropriate.
Right.
Mark, jump in there, I'm sure. And
Yeah,
I know Jim has an opinion on this as well.
Yeah.
I'm a pragmatist, so as long as you can watch your tone, yes, I'm all for the parties sharing briefs. Ideally, as far in advance of the mediation as possible. If there's insurance and there's roundtabling, probably that's something that they're going to need, you know, well in advance of the mediation. For sure, not an argument to spring on them at 4:30 on a Friday afternoon when the carrier's East Coast. So if you're able to share briefs a week in advance, that's got a lot more chance of being considered for the mediation as opposed to the night before or the morning of. So I'm a pragmatist there. Now, I know that some people put a lot of time into detail, you know, analysis, timelines, very, you know, fine point legal argument, especially if we only have a half day to get through this. If you're not inclined to share your whole brief, share that. That's going to help us to be able to use the time that we have as productively as possible. I'm not going to be able to get through 40 dates with a half-day mediation and them give me a response, and then you give me a response to their response, and them give me a response to the response that you gave to their response. It's just not going to happen. But if you send the other side your timeline, or if you send the other side just a mini brief on here's why we think that this new case that just came down or this new law that was just passed is really going to be critical to our view of things, send that to the other side. Include me as a CC if you want. Include any magic language about how it's being produced pursuant to mediation confidentiality. Or if you do share your brief, you're welcome to send me a confidential addendum or an email. You know, here are the things that I didn't want the other side to know, but I do want to make sure that you as the neutral are aware of.
That's a really important point, Mark. And
I agree.
It's you can share things with the mediator privately that go beyond what you want the other side to be aware of. And I find I'll keep this just a couple of sentences. Where you are in the case can make a big difference. If you've got, you know, a heavily litigated case and you're getting close to trial date and they come to you, what's the dynamic? The parties are disgusted with each other. They're tired of paying their legal bills, and the lawyers probably don't like each other either. I find it almost counterproductive in that scenario to expect them to trust the other side with what they want me to know. Whereas if it's at the beginning of the case, more sharing, I think, is productive for creating a collaborative environment. The heavily litigated cases, my job as the mediator is to try and build trust. And I know going in, they're not going to tell the other side what they want me to know. So why insist on it? You can have a public brief and a private brief. It can be a very, very useful tool, whether it's a brief or an email or get on the phone or whatever. But you probably want your mediator to know more than you want the other side to know about your position. Don't be afraid to split it up that sort of way. As I say, we could do an entire program just on this. We've got several really good questions here, and we're at the top of the hour. For folks who need to sign off, you're welcome to do it, but we're here for the duration, and we'll try to get to these questions. Stacy, Mark, just in a few sentences, do you have any closing thoughts before I get into the questions?
I want to say be prepared for the mediation. That is the number one thing to optimize the outcome for your client. Know the facts, get your mediator what they need to know so they can make the arguments and understand the case. Make sure your client understands what's going on. I think most of us mediators would say lawyer preparation has a big impact. It allows you to give us the information to get the other side to evaluate the case most similarly to you. And preparing a good mediation brief is part of it, or making in any form you can. I'm not such a stickler with format. I just want the information so I can help you and be productive and be worth it for you using me. So be prepared, get us what we need to get your cases settled.
Mark?
Yeah, I wanted to circle back on one thing that we were talking about earlier, which was settlement discussions. And those really, I've had more mediations blow up because of expectations than anything else in a very long time. I have to close my window 1 second. So let me know what the settlement discussions have been. Let me know when they've been. And it's not just the discussions that you have had with the other side. If there's an adjuster who made an offer, let me know the adjuster's offer. That's going to set expectations. Prior counsel, personal counsel, was there a severance if this is an employment case? If somebody was offered 6 months of severance and you're showing up at the mediation offering 2 days of wages, the other side's going to notice that. And they're going to say, well, if we didn't take 6 months, why are we going to take 2 days? So that really is one of the most critical things to do to help me to be able to help you. Likewise, if you're making a move up or a move back, give me a heads up so that I can start to prep the other side and try to minimize, any potential blowback that we might have so that we can keep our time as productive as possible. Again, help me help you.
Let me just segue into a few of the questions here before we do thank yous and all that good stuff. One question you just touched on, Mark, is on the question of sharing. What should you share with the other side, particularly about settlement authority, if you have an insurance type case? That's Stacy.
I don't think you should share settlement authority with the other side in a brief, or I don't think you should tell your authority or your bottom line until you're there, because then that's what they're going to go to and try to push you below it. So do not share settlement authority. And I don't think you should tell your mediator a real bottom line. First of all, no bottom line is a real bottom line because you take a penny less. But besides that, I don't think you should share settlement authority with anyone until you're close.
Yeah, certainly no reason to share your bottom line with the other side or your carrier's authority with the other side at the outset. Exactly as Stacy said, where settlements become possible is when things change. If you come in and you've only got X amount of authority and you tell the other side, I've only got X amount of authority, then they're not going to be listening to all of the arguments that you've prepared your mediator to make. They're just going to say, well, I don't want X amount of authority, so that's it, we're out of here. I am fine with you telling me, we're going to need to, powwow if this goes over X number. That's fine, but numbers change, demands change. What it is that people are willing to offer or carriers are willing to offer changes all the time. It may take a mediator's proposal in a couple of days to get some additional authority or to do some further, work on a particular issue to be able to get your client down. So I never want to know that. There was a very young plaintiff's attorney that I worked with early in my career who wanted to just tell me the number, at the outset of the mediation. And I appreciated that they were, demonstrating trust in me. I'd worked with their firm a number of times. And I said, tell you what, you really want to let me know the number, write down your bottom line on a piece of paper. Don't tell me let's settle the case. And then after we settle the case, then you can show me your piece of paper. And he did. And his bottom line was substantially less than the parties ultimately were able to settle. And I asked him, you know, if you had told me that bottom line, do you think you would have just gotten the settlement that you got? Or do you think that you would have gotten your bottom line? Or do you think you would have gotten less than your bottom line? And the exact same thing could be said on the defense side of the V as well. If you're telling your mediator, especially early on, I'm never going to go beyond this particular number, what if the other side doesn't need that much money? You know, the fancy term, since Stacy and I both went to the Strauss Institute and we're both on their adjunct faculty, the zone of potential agreement. If this is a case where, you know, one side has a really large zone of potential agreement with the other side, then where does that case wind up settling along that zone? And if it's clear that there's no zone of potential agreement, is your neutral going to give up? If you say on the defense side, we're never going to pay more than 10, and on the plaintiff side, we're never going to take less than 500, now what? So no need to share that, especially not early.
And you want to capture as much value within this zone of agreement, right? So work on it. I love the example you gave, Mark, because there's so many times somebody says, I can never go beyond 5 figures and they go into 6, or somebody says, I'm not taking less than 6 figures and they do. So I just say, keep that to yourself. Let us work for you to try to get you the best agreement you can. Yeah.
Yeah. Let me just check one other question here, and then we should probably start wrapping it up because we're asking people to indulge in overtime. What
we won't personalize it if you drop out.
Exactly. Can you, there have been a couple of questions about, can you give a little bit more discussion to discussing barriers to settlement? I know you touched on it during your earlier things, but a couple of people have asked follow-up questions on that. You want to amplify that, Stacy and Mark?
Yeah, do you have specific follow-up questions, or do you want us to just talk about it more?
The questions all go to that, it seems. And so it, you know, why is it so important to you? And is there, if you perceive something, is that something you should share with the other side?
If you perceive a barrier?
Yeah.
Well, it depends, and it depends how to share it. I think most of this is about barriers to settlement. We are trying to move the negotiation forward, avoid any obstacles in the way. And as we get past one barrier, sometimes other ones arise. So many times the barrier to settlement can be the personality of someone in a room. It can be a culture, it can be ego, it can be high emotions. Look, you've just been hurt. And now they're asking you to take X amount of money when $10 million isn't going to cover it. And they're offering you $200,000. These are the types of barriers that we have. It's driven by so many factors. And if you talk to anybody who mediates regularly like we do, every case is different. Sometimes something arises and I couldn't have anticipated it. Sometimes it's finances, right? Mark and I both have had a ton of cases where the high SIR, the company doesn't have money, they need pennies on the dollar. We got to get profit and loss statements and tax returns and whatnot to show that what they're saying is true. And so we need some document sharing. We're versed in that. Sometimes when they don't have money, this is a great time for our creative resolutions, right? So I've resurfaced pools and put on new roofs and sold houses in a certain way. And there's a million things we redo. I just redid a movie deal the other day. That was really great. So there's so much we do, and there's so many ways that we can add value for you in helping you deal with barriers to settlement. The only thing is we need to know about them. So we are, and Mark and I teach on this. We teach how to ask the questions and how to get people to open up and whatnot. Us mediators, we're skilled at doing this so that we can help you identify what these barriers are to settlement, but it is critical. And I don't want a barrier that arises at the last minute, right when we're signing the deal, although that can happen too, because nobody brought it up. So we are trying to identify, and I always tell mediators, look at what these barriers are to settlement. Try to identify them as early as you can. But sometimes it's drafting of the language and we're in there trying to like keep this deal together. So help us help you. I love that, Mark, as like the theme, help us help you. But barriers to settlement, to me, if I were to think of the most important thing for us mediators to be identifying and dealing with is that. Then we want to coach you to be productive in your negotiation and whatnot. But we can't let a lawyer who wants to bill. It's a business case and now he just wants to build the case. So he's not going to let his client settle. That could be a barrier.
Huge.
Help us. The dynamics can be anything. And Mark, go ahead, jump in on that as well.
Yeah, I have so much respect for advocates. I mean, you know the case better than we possibly could. You've been living the case for longer than we have been. Stacy and I both said, you know, we read our briefs first thing in the morning. You've possibly been working on this case, maybe have met this client, you know, for the first time a couple of years ago. You know this case better than we do. You know what the obstacles are likely to be. You know, an example very much springs to mind. I have insurance background. I am a total insurance nerd. I have been former insurance coverage counsel, not insurance defense counsel, but coverage counsel. Something unique about my background. And defense counsel mentioned in a brief, right on page 1, this is a burning limits, low exposure policy. And okay, you know, I knew immediately what they were talking about. And so I was able to ask the question, well, how low are the limits? 100 grand. Okay, so this is a burning limits policy, which means that every dollar that you're spending on defense cost is reducing the amount of coverage. How much have you billed to date? About 80 grand. So we can all do that math. 100 minus 80 equals 20. And is the defendant still in business? No. Are there any assets? No. So on that particular day, defense counsel is telling me every hour we spend in mediation is less money that her carrier can put into plaintiff's pocket. She doesn't want to be there. I mean, to her credit, she did not want to be there and bill until the very last penny on the policy. And my job was to explain all of this to somebody who was not particularly savvy to insurance, not particularly savvy to litigation, and who is the plaintiff. It was a rape case. And we can call this sexual harassment, but it was rape. It was rape, it was substance abuse, there were cultural issues. And my job was to explain, you know, I want to listen to everything that you want to tell me. But please understand that the longer that we take, the less money we can put in your pocket. Everybody wants to put as much money into your pocket as humanly possible. And it's not going to be enough. It's not going to be nearly enough. But one of the big obstacles was defense counsel kept telling plaintiff's counsel, this is a burning limits policy, without explaining what that meant. And without explaining how much of the policy limits had already been eroded and how the policy was about to exhaust and what that meant for her client. So telling me that and helping empower me to be able to share that not only with plaintiff's counsel in a way that plaintiff's counsel had understood, because fortunately she had never come across a case like that before. And for me to be able to treat that particular plaintiff with the respect that he deserved in addressing something that, you know, this is why I say that we have a legal system, not a justice system, because there's no justice in a settlement that is not properly compensating somebody. But if that's all that there is, then that's the very best that we're going to be able to do for that person on that day. But
Yeah.
As defense counsel equipped me with that information at the outset, I didn't need a 12-page timeline. I didn't need to know that sexual harassment is illegal in the state of California. Tell me that. That's what the mediation is going to be about. Tell me that. Help me help you.
And I just want to highlight with the insurance, it really is important. It drives so much in the mediation. Like the other day, no one told me there were 2 coverage counsel coming in. Nobody even told me this. I could tell there'd be coverage issues, but no one talked about it in the brief. It was the entire mediation plaintiff trying to convince coverage counsel that it was a legal malpractice case, that the lawyer was covered. That was the whole mediation, and no one talked about it. They talked about the substance of whether or not he had acted negligently. So I want to say to you lawyers, really take a look at insurance and see if it's a driver. High SIRs can be a problem. What Mark said with these burning limit policies, all of it, really take a look at the insurance and let us know the situation so that we can help you with that.
Where's the money coming from?
Yeah.
Yeah.
It's ultimately a big part of what it is that we're using to settle your cases. So let us know.
With that, we've indulged people a good bit beyond our 1 o'clock cutoff. I just want to thank both of you so much. It's been, as always, a pleasure to work with you. But I hope that you folks out there who are still listening have a much better understanding of how to use your mediation briefs more effectively. Mark's got the best phrase for us help you. And your brief is the central part of it. Tell us what we need to know. If you need to say some stuff privately, say it privately. But you have to get out of pure advocacy mode if you're going to have a successful mediation. And it's the mediator's job to try and build the trust during the mediation. And it's especially difficult in a heavily litigated case. But help us help you. If we need to know stuff that you don't want to tell the other side, tell us privately. We'll read it. But be respectful of the boundaries that we've been talking about. Keep it focused. I'm sorry?
Or call
Stacy. Yeah.
Yeah, exactly.
All right. Ladies and gentlemen.
Thank you all for
thank
taking
you.
your time during lunch. We appreciate it.
And
Thank you to
on behalf
Jim
of
and
all
Mark
of us,
and everyone.
on the committee, Stacy and Mark, thank you so much for doing this. And hopefully we'll have you back again soon. So
Go
Thank
team.
you for including. This was great fun.
yeah, super duper. All right.
Thank you, everyone.
Take care, everybody.
Thanks, Jim. Appreciate it.
See.
Go team.
Pleasure.
All right. Take care. Have a great day, everybody.
Ciao, ciao.